Good morning, everyone. Welcome to this webinar. So just some housekeeping items before we get started. Please submit your questions in the chat box at the bottom. It's the Q&A function. And then if there's something that you're interested in that someone else has already raised in that Q&A, you can upload it. The session will also be recorded and available on the BRSL website and our YouTube channel after the event. I'll put a link in the chat where you can follow us and join our mailing list so you can hear about when we post that video and also about future webinars. And with that, I'll turn it over to Elaine to introduce more about the webinar.
Thanks, Vivian. Hello, everyone. Welcome and thank you for logging on. My name is Elaine Korzak. I'm a research scholar here at the UC Berkeley Risk and Security Lab, where I work on questions of international cybersecurity governance, including commercial spyware governance and regulation. And we're very thrilled for you guys to join us for the second installment this fall of our webinar speaker series, Exploring Governance of Commercial Spyware. And the series is meant to explore different perspectives on how to move the spyware governance debate forward. And we want to give governmental and non-governmental stakeholders a venue to present their views on the issue. And with that, we want to contribute to moving the global debate forward at a time when we have seen increased political momentum. Now, for those in the audience who are new to the topic, commercial spyware has been a global policy problem for well over 10 years, but only in the last 2 to 3 years, we have seen increased high-level political attention and momentum to tackle this issue meaningfully and comprehensively. Most notably, we've seen that the governments of the United Kingdom and France have launched a global multi-stakeholder process called the Pall Mall process, which has really reinvigorated the global governance debate. Now, in this context, we're very delighted to welcome today's speaker, who will focus on a more fundamental question in the governance debate. Our speaker will look at the question of legitimacy of surveillance by state actors, and with that, we'll be taking a step back from current efforts and implementation of those efforts. And Sarah will be arguing that these questions of legitimacy need to be addressed first for us to meaningfully move forward internationally. She will also provide insights from her recent work on a report that has just come out by the Special Rapporteurship for Freedom of Expression of the Inter-American Commission on Human Rights. This report speaks to the increasing normalization of surveillance in the region, in the Inter-American region, and it also includes testimonies of individuals who have experienced spyware infections themselves. Now, our esteemed speaker today is Sarah McKune, who is a U.S. lawyer and independent consultant with expertise in international human rights law and the human rights impacts of digital surveillance technologies. Sarah has consulted for the Special Rapporteur for Freedom of Expression of the Inter-American Commission on Human Rights, as well as the UN Special Rapporteur on Freedom of Opinion and Expression. She has also served as a consultant with Amnesty International regarding surveillance-related strategic litigation and private investment in the spyware trade. She is also a senior legal advisor to the Citizen Lab at the University of Toronto. Now, without further ado, we welcome our speaker and we thank her for taking the time and walk us through her perspective today. With that, over to you, Sarah.
Great. Thank you so much, Elaine, and thank you to the Berkeley Risk and Security Lab for having me participate in this webinar series. It's a pleasure to be here. So I have a few slides that I will go through, and we can base some of the discussion on that. Also looking forward to fielding some questions at the end and looking forward to the fruitful discussion. So the question of legitimacy in state surveillance operations, I think this is an essential foundational question that needs more attention in the debate because so frequently we've been seeing legitimacy sort of assumed in the field, legitimacy of the use of these very intrusive technologies to conduct surveillance operations. And I think there needs to be greater attention to state compliance with international human rights law and the legal standards and norms that operate in this space. So to begin, the surveillance landscape in 2025 is exceptionally complex. There are myriad and intersecting forms of digital surveillance, many of which are increasingly used in combination by state actors. As Elaine mentioned, we've seen extensive use of spyware. There are other tools as well, facial recognition tools, tools incorporating biometrics, geolocation tracking tools, tools for exploitation of the SS7 signaling systems network. That's part of the telecommunications protocols for communication between mobile networks. There's network monitoring, there's advertising intelligence, AI facilitated analytics, and the increasing prevalence of data brokers who obtain data, whether it be from private companies or other databases, and consolidate it and have provided it to government and other clientele for use occasionally in surveillance operations. And the NGO Access Now has described this state of play as, surveillance is an apparatus and it's a mixture of the technologies. It draws on information from digital profiling, ICT providers, social networks, and other sources, as well as facial recognition, spyware attacks, and other intrusive measures. Access Now noted that this is one of the most critical parts of surveillance in Latin America in particular as a whole. It's not only technologies, it's the use of tactics and techniques that are working together. And I think, this really exemplifies the complexity of the space, the rapid evolution of the space, and it's something that requires significant attention. I've included here on this slide a screenshot of the website surveillancewatch.io, which I would highly recommend to individuals who are interested in the companies that are involved in this space and how some of those tools have been appearing globally. Surveillancewatch.io lists almost 700 companies that are active in providing surveillance technologies worldwide. We've also seen increasingly frequent surveillance abuses, and reporting is coming out about these abuses all the time. Research and investigative journalism has uncovered many uses of intrusive surveillance technology against what would be considered under international human rights law to be, non-criminal use forms of exercise of human rights. So rights defenders are being targeted, journalists are being targeted, lawyers, politicians, family members, a whole range of individuals have been subjected to these intrusive surveillance measures. And you might have seen just this week, there was reporting that came out in Mother Jones. I've included a screenshot here regarding a surveillance tool that exploits the SS7 network, the signaling systems protocol, for location tracking purposes, finding individuals' mobile devices, which allows you, of course, to track an individual. The report noted, a whole range of individuals who had been targeted with this tool, including people who were targeted, on the basis of personal vendettas, as well as even an individual who was preparing a book regarding Pope Benedict. And the reporting suggests that there was tracking going on even from the Vatican in order to find out the source of the information regarding the Pope. And so these surveillance tools are being used for many purposes that are in fundamental contradiction to the protections of international human rights law. We can expect that this surveillance will only expand. I believe we're seeing a trend towards the normalization of surveillance, and there are numerous drivers involved here. One, of course, is that, this is a very profitable space that many companies are participating in because of the allure of profits from industry clients, expansion of clientele, expansion of uses. So private sector involvement is significant. Um, some other surveillance drivers include conflict. Conflict around the world has contributed to, advances in surveillance technology, more widespread deployment of surveillance technology. Also, efforts to address migration have been significant surveillance drivers. NGOs like the Electronic Frontier Foundation in the United States have been tracking quite a bit of this surveillance technology that is being deployed specifically in efforts to engage in border externalization and border control. We can see quite a bit of surveillance advances happening there. We are also seeing more widespread government digitalization, rollout of digital identity systems, and just the increasing integration of the digital space into individuals' lives is providing fertile ground for surveillance companies and surveillance activities. And so this is definitely an area that is of significant concern, will continue to evolve, and we need to address the normalization that is at play here. In terms of the human rights impacts that are the result of surveillance abuses, there are a wide range of rights impacted, and many of those flow from the foundational principle of personal autonomy, your ability to engage in thought, expression, activity, movement that is reflected in your digital presence, whether it be, information that you're looking up online, the location of your mobile device, which typically suggests your location. A whole range of rights are at issue here. So, of course, the right to freedom of expression, the right to privacy, rights to freedom of association, and numerous other rights. We have seen significant targeting of political dissent, human rights defense, and investigative journalism. So surveillance has made its way well beyond the bounds of lawful criminal investigation and counterterrorism measures, which were the original justification for some of these extremely significant intrusive surveillance measures. I've included here a screenshot from a Citizen Lab report. This concerns one of the individuals who acted as a human rights defender in the UAE, Ahmed Mansour. He was one of the first people who experienced infection with Pegasus spyware that was able to be concretely identified and tracked. Indicators were gleaned from that infection, and it was quite alarming. Ahmed Mansour had been targeted with three different types of spyware: Finfisher, Hacking Team, and NSO Group's Pegasus, and is now imprisoned in the UAE for his rights defense work and his writing. And so that's one of the, early examples of targeting of human rights defenders with these types of tools. And of course, we've seen numerous examples since then. The Pegasus project that came out a few years ago, numerous other reports, research reports, investigative journalism reports documenting some of these attacks. I think civil society has also grown increasingly aware of the nuances of some of the harms that ensue when these surveillance technologies are used against individuals there is more awareness of the intersectional and gender-based harms that flow from surveillance abuses. Individuals may experience more significant harm when they're part of vulnerable populations, when the information that is obtained about them could be used to pressure them in their own social circumstances. So we've seen female rights defenders experiencing particular harms that are unique to them. We've seen members of the LGBTQ plus communities experiencing particular manifestations of harm. Some individuals have been pressured to go public with their sexual identity because of spyware infections and the fear that the information that is obtained on them will be used against them. We've also seen these tools used in campaigns of transnational repression, where you may have diaspora communities or people who are living in exile for their rights defense work in their home countries who may flee the country or move the country in order to continue to engage in their work. And they are actually targeted still within reach of their home government through digital means. And so we've seen spyware used in campaigns of transnational repression, which is also quite concerning. One thing that there has been more and more attention to, including in the recent report of the Inter-American Commission on Human Rights Special Rapporteur on Freedom of Expression, as his report pointed out, these rights violations that involve surveillance technologies have a continuous nature. The rights violation is ongoing because of the significant concerns that are raised when an individual's mobile device or laptop or other communications platform is subject to this type of surveillance. There is a well-based fear that the surveillance will continue, that information that is obtained through the surveillance could be used against the person down the road, whether it be to cause them physical harm, whether it might impact their family, whether it might be used to publicly shame them. So these rights violations without access to remedy are continuous and are quite severe in terms of their psychological impact as well as financial impact and other impacts in an individual's life. As Elaine mentioned, we have been seeing more momentum building around efforts to address surveillance abuses. Some of the early efforts involved export regulations and reforms to export regulations in order to kind of rein in the sale and the propagation of these tools to entities that were likely to abuse them. Unfortunately, we've seen numerous challenges arise in the export regulation context because it is very dependent on how the export regulations are actually implemented by licensing authorities, by particular states in which some of these companies are based. And we even saw reference, for example, in the recent Mother Jones report that I mentioned at the beginning, to quite deliberate efforts by companies to relocate to jurisdictions where they face less strict export regulations in order to continue their sales unfettered. So export regulations have improved, but of course, numerous obstacles still exist in that context to curbing the dissemination of these tools that ultimately end up being implicated in surveillance abuses. We saw the European Parliament initiate an inquiry to investigate the use of Pegasus and similar surveillance spyware in Europe, and numerous findings came out of that inquiry, which have been quite helpful. But of course, again, it depends on implementation by particular states to take those recommendations and effectuate them. There have been calls for moratorium on the sale, transfer, and use of spyware. The government of Costa Rica signed on to such calls for moratorium. Numerous UN and other entities and legal experts have signed on to such calls. So there is, more widespread awareness and, attention to the need for better regulation in the space. Um, you know, Very interesting efforts have been undertaken in the former U.S. administration. We saw over the past few years that there was quite a bit of attention to trying to shape the market, trying to, uh, you know, um, create consequences for companies that whose tools were implicated in these abuses through efforts such as inclusion of particular companies on the Commerce Department's entity list, which restricted the sale of items to entities on the list. We saw NSO Group end up on that list. We saw visa restrictions and other sanctions applied against individuals and entities who were implicated in spyware abuses. We also saw internal government regulations or through executive action restrictions on the government use of tools that were also appearing in some of these quite severe surveillance abuses. So the U.S. did take a number of measures that provided an excellent example for how to ensure that these types of behaviors within the market face consequences. So we saw some progress in that respect. As Elaine mentioned, the Pall Mall process is ongoing. The multilateral, multi-stakeholder initiative led by the UK and France to develop a code of conduct for states and for industry participants around the commercial cyber intrusion capabilities. And then we've also seen a number of legal actions underway against companies whose tools were used against individuals in violation of their human rights. And legal action has proved quite challenging. It's important to reflect on the numerous obstacles that individuals face in obtaining remedy through legal action. There are numerous jurisdictional hurdles, evidentiary hurdles, and thus far, cases brought by people who have actually experienced intrusive surveillance have not resulted in a judgment in their favor. We've seen quite a few dismissals on jurisdictional grounds or what have you. Some of those actions are ongoing. The only legal action to date that has resulted in what one might characterize as unqualified success is the case that WhatsApp brought against NSO Group regarding NSO's misuse of WhatsApp servers. And of course, that case involves a US company and does not necessarily reflect the experiences of the individuals who are actually subjected to spyware. So there are numerous limitations at play on that front, and there needs to be greater attention to remedy in this space. Now, reflecting on this landscape and the documented cases of abuse thus far, it truly raises the question, what does legitimacy around the use of digital surveillance technologies mean nowadays, considering the rapid expansion of the market, the regularly documented cases of misuse, the access across the globe to these types of tools, ever increasing access. What does legitimacy actually look like if we're talking about how to use surveillance tools in a manner that conforms with the requirements of international human rights law? And I think it's interesting, to reflect on, you know, the standards that have come out of the UN, for example, the UN Human Rights Committee, which noted in its general comment number 34 on freedom of expression that restrictions on the right to freedom of expression may not put in jeopardy the right itself. And the relation between right and restriction and between norm and exception must not be reversed. And I am quite concerned, given the landscape that was just described, that that relationship has been reversed. And it's interesting to note in the Pall Mall process, there has been quite a bit of emphasis on highlighting legitimate use cases, um, you know, um, ensuring that states continue to have access to these tools and this expertise because there are legitimate use cases. I've included a quote here from the Pall Mall Process Code of Practice for States that came out not too long ago. Many of these tools and services can be developed or used for legitimate purposes. And that informs quite a bit of what's happening in the Pall Mall process, this emphasis on maintaining access so that states can continue to engage in surveillance operations that rely on these tools. And so I think we do need to consider whether legitimacy is being sufficiently addressed by states in this space, or whether we are creating the conditions for continued impunity, both of states and of private sector participants in the market. And in order to do that, I think we really need to go back to first principles, as Elaine noted at the outset, really drilling down on state compliance with the international human rights law standards that are out there, the norms that are out there, to ensure that human rights are complied with, that the law on human rights is complied with in any deployment of surveillance technology, trying to rein the abuses in. And as was noted at the beginning, I recently worked with the Office of the Special Rapporteur on Freedom of Expression at the Inter-American Commission on Human Rights regarding this report that was published this month, The Impact of Digital Surveillance on Freedom of Expression in the Americas. And in working with that office, it's become quite clear that inter-American jurisprudence is some of the leading jurisprudence on protection of human rights when it comes to surveillance technologies, and can offer quite a bit of useful analysis to address this question of legitimacy. Just to provide some background regarding the inter-American space, as many on this call might know, the Organization of American States is the regional body operating in the Americas that addresses multilateral issues and includes human rights organs such as the Inter-American Commission on Human Rights. And it also is the basis for the Inter-American Court of Human Rights, which is an OAS-based entity that reviews cases, sometimes on submission of the IACHR, also, other cases brought by individuals, and has issued a number of opinions that pertain to freedom of expression and recently the use of surveillance. Within the OAS, we can rely on the American Convention on Human Rights, which supplements international law, that exists, such as the ICCPR, the International Covenant on Civil and Political Rights, and other tools. The American Convention on Human Rights applies within this region And it includes, much of the recognition that is contained within other international instruments regarding the scope of human rights, such as freedom of expression. But it also includes some additional material that is quite useful in our analysis regarding surveillance. And Article 13 in the American Convention on Human Rights addresses freedom of thought and expression. And unlike the ICCPR, it actually includes a provision, I've highlighted it here, that the right of expression may not be restricted by indirect methods or means, such as the abuse of government or private controls over newsprint, radio broadcasting frequencies, or equipment used in the dissemination of information, or by any other means tending to impede the communication and circulation of ideas and opinions. And this is an interesting provision because it really goes to the focus of the Inter-American System on an expansive interpretation of the right to freedom of expression and an understanding that expression should be protected even against indirect restrictions. And in this respect, I think it's quite interesting that when we consider surveillance technologies, um, one, private controls over equipment used in dissemination of information that restrict the right of expression are flatly considered a violation of the right. And additionally, when we consider restrictive effect, um, a pervasive climate of surveillance may be considered one of the identified indirect methods or means that impede the communication and circulation of ideas and opinions. Because if there is a public understanding that particular communication platforms or technologies are being monitored, that will have a chilling effect and violate the right to freedom of expression. So the American Convention does offer some additional basis on which to challenge surveillance abuses. Another interesting aspect of the work of the Inter-American System is this recent opinion that came out of the Inter-American Court of Human Rights. This case was brought by the Jose Elvira Restrepo Lawyers Collective against the state of Colombia regarding measures that were used against members of the collective that included, intimidation tactics and surveillance, long-standing misuse of state authority against these individuals. And surveillance was an important part of the case. I found this opinion to be extremely instructive to the current surveillance climate. It recognizes that, in any state use of surveillance technologies, one, of course, you have to fulfill the requirements of international human rights law. As individuals on this call likely know, you must fulfill the principles of legality, necessity and proportionality, and legitimate aim. But the Cahar case here was interesting because it elaborated further the type of criteria that would tend to establish the legitimacy of a state surveillance operation. And so I think it is instructive when we consider the broader question of what would legitimate use of surveillance technology look like. And some of the pieces that the court drew on here were, not only the fulfillment of the well-understood requirements of human rights law, but also a robust domestic system for control of the use of surveillance technologies. So that includes, not only authorizing legislation, but also effective ex ante oversight, essential restrictions on use, record keeping, and other practices that would tend to establish proper control of the use of these tools. The court also recognized the need for an independent civilian oversight authority, which I found to be quite remarkable that this was acknowledged by the court. There does need to be some kind of civilian oversight of these operations because of the scale of the potential abuse. And this will require greater transparency by state entities regarding how they use these tools. The court recognized the need for a mechanism for remedy and reparation in the event of surveillance abuse. And we've seen that this has been a frequently missing piece from the discussion, the issue of remedy and how individuals can be made whole after experiencing these abuses. As I noted earlier, the use of surveillance tools can result in continuous violation of rights because of the uncertainty that they create in individuals' lives and the fear, the well-founded fear that people may have for themselves and their families about what's going to be done with the information that was gathered on them or how they might be tracked. So a system, a mechanism to provide true remedy and reparation when these abuses occur. That is really a fundamental part of a legitimate system for the use of surveillance technologies. So the Kohar case was quite instructional there. The Kohar case also recognized the right to informational self-determination, which was quite remarkable. This concerns the protection of personal data and the capacity of individuals to control how their personal information is collected, processed, stored, and used by state entities. So it's really a right to access and control one's personal data. And we've seen some movement on this front over the past years, particularly in Europe, around the issue of data protection and what rights individuals have to their data. And recognition of a right to informational self-determination is, in my opinion, truly foundational to reining in surveillance abuses because, as I've noted earlier, the means of obtaining data on individuals are rapidly expanding. The surveillance tools on offer are expanding, and the notion that individuals have control of their personal data is becoming less and less of a reality. And I think that needs a serious course correction here. And, it's interesting. I find it useful sometimes to engage in this thought experiment of, well, what will people in 100 years think when they look back on this space and how things developed over this time? You often have these developments where they prove to be turning points in kind of the evolution of human society and the ability of humans to flourish, things like advances in medicine or what have you. And we look back on 100 years ago and we think, people lived in the dark ages back then. Like, how could they have operated without this? And I feel like this notion of the right to informational self-determination is going to be one of those critical issues. Like, this is an area that we need to mobilize around now because this private rush, the private sector rush on acquiring our information, acquiring our data, and widespread misuse of personal data, I think is something that needs urgent attention. So the Kohar courts jurisprudence here on right to informational self-determination, I think is essential. The court also recognized the right to defend human rights as an autonomous right. And frequently, when we talk about rights defenders and other operators within civil society who work on these human rights issues, We are addressing their right to freedom of expression, their right to privacy, but actually recognizing the right to defend human rights is itself critical because uh, defending human rights performs such an essential function in society. It encourages, democratic discourse. It addresses social problems, and it's fundamental to the to human progress, really. The right to defend human rights and call out abuses of power was recognized as an autonomous right here, and I think that's something that should be celebrated and discussed more widely. Interestingly, there was also a concurring opinion in the Cahar case that noted the emergence of a potential right to systems integrity, which they considered to be the right to maintain security and integrity of digital devices against unauthorized access. And this was considered to flow logically from a right to informational self-determination. So that's another area that should be carefully reviewed and considered as we move forward. So in terms of charting a path forward, you know, if we want to address this question of what legitimate surveillance is, what is legitimacy in state surveillance operations, we need to ask ourselves how we can modernize accountability structures to address digital surveillance. And this really goes to fundamentally what states are doing to effectuate the international human rights law and the norms and laws to which they are subject regarding surveillance. So, three areas of particular concern that require attention in terms of modernizing, and which the Cahar court pointed out. Number one, transparency. We need more transparency in this space. And of course, states do have a legitimate need to maintain some secrecy around these operations. Obviously, if they're engaging in surveillance that is intended to prevent criminal action, intended to prevent terrorist incidents, they need some secrecy to be able to conduct their operations, but that secrecy is not unqualified. And so we need a fit for purpose system that brings more transparency to the space, because asserting national security cannot be carte blanche for not releasing any information on these activities. Ultimately, that will undermine accountability and not necessarily provide any additional benefit in terms of the effectiveness of surveillance operations. And there's been quite a bit of work that's already been undertaken in this respect. The Organization of American States has a model inter-American law on access to public information. The global principles on national security and the right to information, which are commonly known as the Schwanny principles, are also another source of useful standards on how to release information that concerns national security. But without transparency, we won't be able to track abuses. We won't be able to understand the entities or technologies that are part of this space. And transparency will be essential to both oversight and remedy efforts as well. Oversight. We need technical measures to promote oversight. So to the extent that private sector actors are providing these tools, doing so in a way that reflects the need for oversight of their use, whether it be, licensing systems that are built around kind of a bifurcated approach to oversight where the entity using the tool needs authorization to activate the license from, the appropriate oversight authority, technical means of oversight, and also the civilian oversight component that I mentioned earlier when discussing the Cahar case will be important. And then, of course, remedy, the right to remedy, and the derivative right to notification of being subject to surveillance are quite critical here. Um, we have seen that remedy has proven so elusive to individuals who have actually experienced these very severe human rights impacts, and that needs to be prioritized. Real remedy needs to be possible in order to prevent a continuous violation of rights from occurring. There needs to be some means to understand what information was taken, where it's at, whether it's been destroyed, whether there are any assurances of non-repetition. So all of those aspects need to be addressed by states as well. So I'll stop there, and I'm looking forward to discussing this with Elaine and with those on the call. Thank you.
Hi, thank you, Sarah. Thank you very much for this presentation. This was really a tour de force on all things surveillance and the attendant international human rights law framework. So I hope the audience got a lot out of this. We've really had a very good mix of big picture paired with a lot of details on relevant and recent jurisprudence in this area. Now we have 10 minutes left, and I suggest we start. We have two questions from the audience. Now I'll just read them. I think we can take them in a pair since they're related. For those who can't hop over to the Q&A section. You mentioned normalization of these technologies. We frequently hear about the issue of people willingly adopting technologies that are networked, part of the Internet of Things, which seems to increase opportunities for spyware. Although this doesn't necessarily legitimize these technologies, to what extent would you say this normalization is being driven by individuals versus the government? And a related question, have there been efforts to address these spyware technologies from the side of companies that produce smart devices, TVs, cars, etc., that are part of the Internet of Things? Very good set of questions.
Yes, thank you for those excellent questions. Yes, it is interesting because I think the first question in particular raises the issue of bargaining power and the issue of consent. And I think when we're asking ourselves, well, what role do individuals play in the normalization of surveillance? I think we do have to confront this question of, well, to what extent are they being given a choice? I think, you know, it's kind of a sad reflection on where our society is at, that, a lot of people assume they don't necessarily have a choice because just the collection of personal data has become fundamental to the operations of many of these companies, whether it be large internet platforms or providers of technologies that are part of the Internet of Things, whether it be your your smart TV or your refrigerator. There's not much of a choice left anymore for individuals to kind of find an option that doesn't include collection of personal data. And I think that goes to this right to informational self-determination. There needs to be some intervention by the government to kind of effectuate more choices in the space and to encourage more digital literacy, um, fewer adhesion contracts, more options for people to control how their data is collected and used. And so there does need to be more movement in that regard. And a lot of it is coming out of, some of the data protection initiatives that I touched on earlier. But yeah, a lot more work needs to be done because the the bargaining power just isn't there when you talk about an average consumer and what they can expect from a company that would be providing tools that they need. And it also raises questions about the digital divide and who really has the luxury of being able to make these choices, which are important as well. On the second question, have there been efforts by companies that provide some of these tools and services that make up the Internet of Things? I mean, I think some companies are uh, including privacy concerns as part of their sort of model. I think Apple has taken a lot of steps in that regard, including um, uh, privacy concerns as part of what their technologies are meant to address. But I think we need more um, intervention from governments to kind of popularize that. And also, we need more acknowledgement that things like encryption standards and security research should be protected and promoted in order to make sure that we can have some oversight of these technologies and have means of better protecting individuals' data.
Right. Great. We got a couple more questions, so I'll just continue in the order we got them. Thank you for taking the time to be here today and sharing your work and ideas, and was wondering if you have any advice for people in their early career, legal or otherwise, who care about this issue and want to take action towards it.
Mhm. Well, I mean, I would say, first of all, um, keep having conversations about these issues and pushing back on surveillance normalization. I think we're seeing it frequently in just our average lives, like what's happening at our local schools, amongst our local government entities, just pushing back on this overuse of surveillance measures, whether it be social media monitoring or collection of data, just as they manifest themselves in our own experience, I think is essential. And then uh, working towards, human rights compliance, whether that be in career choices or advocacy or just support of organizations that do this work, I think is quite useful too.
Thank you, Sarah. And then our last question is a bunch of questions that we might not have enough time to dig deep into them because we have only about 4 to 5 minutes left on the webinar. But what makes legal action against surveillance abuses such a limited remedy? Why is it difficult to prove harm? And what are the gaps in international law that contribute to this problem?
Mhm.
Good set of
Well,
questions, for
yes,
four
yes,
minutes.
yes. Very good question. And I'm glad we have this opportunity to get a little bit more into depth on this issue. What we've seen in the cases that have emerged thus far is, first, whether or not an individual even knows they've been subjected to surveillance. And of course, that's the crucial, first question. We've seen a lot of people only become aware of the use of surveillance against them because of leaks such as the Pegasus project and investigative reporters reaching out to them. Otherwise they might have had no idea. Given the widespread misuse of some of these technologies, equipping people with a way to understand whether or not they've even been targeted in the first instance is important. And so notification by companies is quite useful, and we've seen some encouraging progress on that front from companies such as Apple and WhatsApp. Notification from governments, I think, is what we'd like to see over the long term. Notifying people when they are, targeted for surveillance, down the road that they were subjected to this measure and what has been done with their data, I think would be the ideal outcome. But it remains to be seen whether or not that will materialize. So understanding that you've been targeted is the first thing. Secondly, gathering evidence of the infection itself. These tools are designed to disappear from your phone, spyware in particular. I mean, it's designed to disappear and leave no traces. Sometimes indicators can be found through persistent work of security researchers, but even accessing that expertise is quite difficult for the average individual. So having means of obtaining the evidence is important. And one thing that was recommended in the report of the special rapporteur that we mentioned here is, whether or not evidentiary standards around surveillance abuses can be modified to reflect that access to that evidence is typically within the exclusive control of the entity doing the surveillance. So addressing the evidentiary burdens. Then also there's issues of resource to bring a legal action, whether or not individuals will face repercussions, whether the court in their jurisdiction is impartial. So there are many, many hurdles to overcome.
Sarah, thanks, and sorry for, we only had limited time for this very good set of questions at the end. But I think the webinar is going to shut down automatically soon. So I just wanted to take this moment to thank you for your time and for your presentation, for your effort in this. We really appreciate the very comprehensive tour de force presentation you gave us. Very insightful. And yeah, with that, thank you to the participants. We'll have another installment, the final installment this semester of the speaker series next November. So look out for those notifications. And with that, I'd like to thank everyone and
Yes,
have a good rest
thank
of your
you
day.
so much for having me. Thank you all.